Counsel, if you're ready, you may proceed.
May it please the Court. David Wells of McGuire Woods, representing the St. Joe Company. With the Court's permission, I'd like to reserve 3 minutes for rebuttal. We seek here a reversal and a remand to the trial court, reversing the trial court's April 21, 2006 order denying a new trial, and more importantly for the purpose of this appeal, denying discovery and an evidentiary hearing with respect to St. Joe's motion alleging fraud in connection with the trial. The trial court, in the way he handled the process, denied St. Joe a full and fair opportunity to present all facts with respect to the alleged fraud, contrary to this court's teaching in Southern Bell v. Weldon, which states that if a motion demonstrates a colorable entitlement, a colorable showing that a fraud has been perpetrated, the trial court shall, not in its discretion, but the trial court shall permit discovery and permit an evidentiary hearing. We presented the trial court with a specific discovery plan identifying exactly what discovery was needed. Originally, the trial court found that to be reasonable with one exception, but ultimately, without permitting any discovery and without an evidentiary hearing, denied St. Joe's motion. In St. Joe's motion, we believe that we have established a colorable entitlement by demonstrating the following evidence. That number one, the 1994 authorization, which is at the heart of this dispute, which was originally attached to the plaintiff's complaint, relied by the plaintiff below in this court, in the Supreme Court, and very clearly at the trial court, was a fabrication. That has not been disputed. It is a fabrication consisting of taking and cutting a signature off an earlier.
But why wasn't this pursued before trial?
Excuse me, Your Honor?
Why was this not pursued before the trial?
The St. Joe Company did not know before trial that it was a fabrication, Your Honor. That's why, and I would submit that...
That's why you have discovery, right?
Yes, you have discovery, Your Honor, and you have the opportunity to take discovery. The record we submit in this case demonstrates that St. Joe did not recognize, did not see that this was a cut-and-paste fabrication until during the process of trial when Mr. McKeever was being examined, and we filed affidavits to that extent. I submit that there is
that was the second day of a 10-day trial.
I believe it was the third day, but yes, a third day of a 10-day trial, absolutely, Your Honor.
And why wasn't it pursued then?
Well, I believe that it was pursued then, Your Honor. The record will demonstrate that during the testimony of Mr. McKeever, what counsel for St. Joe attempted to do as he was sitting there and looking at these documents and coming to this conclusion was to ask Mr. McIver if, in fact, the signature on the 1992 admittedly genuine document for which there is a significant paper trail showing it's genuine was, in fact, simply the same signature on the 1994 document. And the trial court, after objection by Mr. McKeever's counsel, denied St. Joe the opportunity to do that.
That was a question I wanted to ask you. Let's put to one side these post-trial motions. Is it your contention that the judgment should be reversed because of rulings made in the course of the trial?
We have argued on appeal, Your Honor, that yes, the judge's failure to allow St. Joe to at least present to the jury, as he had indicated earlier in the trial, the two documents which were in evidence, and to say to the jury, look, aren't they in fact a cut and paste? Isn't in fact the same signature appear on the second document was error? But frankly, Your Honor, that's a harder stretch. And I think that the better...
Well, for one thing, the trial court never ruled that, right? The trial court said you need another witness.
The trial court said you need another witness. The issue, I think, Your Honor, is a very simple one. The trial court did not say that you had to have an expert witness. The trial court says if you have these two in, you may, in fact, show it to the jury. And I would, at tab 29 of our appendix at page 699, after first saying this is not a proper cross-examination, if it's something you want to present by witness that could testify to the jury, that's what this is, the two of them together. And the jury needs that, you can present that testimony. Otherwise, you can use these documents and put them on top of each other. Once you properly identify this, being one exhibit, as a copy of the other exhibit, there's nothing wrong with putting them on top of each other and showing them to the jury. But this witness is not going to be a vehicle for doing that. Even on the next to the last day, when our case is still open, St. Joe's case is still open, St. Joe could still, in fact, do whatever they needed to do in terms of simply authenticating the two documents for the jury. The plaintiff came in that morning when jury instructions were being discussed and said, wait a minute, we'd like to move in limine, and we'd like to move in limine to prevent any type of discussion of these documents, whether through an additional witness or at closing argument. At tab 30 of the appendix at page 1277, the course first says, okay, I'm not going to let them put up another witness on this, but this wouldn't stop you from presenting them in argument. Plaintiff's counsel persisted and said, no, wait a minute, you need to look at the Clark versus State case and the Huff versus State case, and we submit that this means that you have to, plaintiff submits, that this means that you have to have an expert, and you have to bring in an expert to testify that, in fact, this is a cut and paste. Counsel for St. Joe tried to argue, no, that's a different issue, and as we've argued in our brief, we believe that, yes, if it's Clark versus State, where they're saying, look at the way the gentleman wrote the front of the check and look at the signature on the back, and jury decide if that's a forgery, or Huff versus State, where he says, look at this one document that's got a signature on a promissory note and compare it to a signature on a different document and decide it's a forgery, is a rather different issue than when you're simply laying one document on top of the other.
You're saying, so day 2, day 3, thereafter you thought, well, we're going to be able to argue this to the jury and we're going to be able to do it that way.
That's correct.
And then the rug was pulled out from under you as the trial came to an end.
That's absolutely correct, Your Honor. I think we've established that in a brief, and we've laid out the direct citations to the judge's ruling on that.
Isn't it true that in front that counsel said to the jury, they're the same? You can just look at them and see them. Didn't that happen?
I don't believe so, Your Honor. They were absolutely precluded from making any argument to the jury. The judge says, did they
nevertheless, in the jury's hearing, not say precisely that?
I do not believe so, Your Honor, and that would be at Appendix 28, page 591 and 592 is the testimony, and here's what happened. Let me ask you, sir, to take as long as you want to compare the signatures, where it appears that the signature in the 94 form is not exactly the same signature. Mr. McKeever responds, it's Mr. Beeland's signature. Trial counsel goes on to say, but the question I guess I want to ask you is, does it not appear that the signature on the 1994 form is a photocopy of the signature? He's then interrupted by counsel for plaintiff's objecting that he's not a handwriting expert and saying this is not an issue that has been made in this case, and now this attempt to suggest that what he did was doctor up and fake this document is outrageous, Your Honor. Sustained. That was the extent of it. So I would submit that no, St. Joe has not and was not permitted the opportunity to present this to the jury.
Well, there's no dispute, is there, that the terms of the 94 agreement were in effect, that Mr. Beeland testified to that?
I'm not sure that I follow your argument or your question. If the question is, had Mr. Beeland testified that he continued to be an agent through that period of time?
Well, didn't he testify that the 94 document had been approved by St. Joe?
What Mr. Beeland testified, and we have cited his entire testimony on that, pages 9 and 10 of our brief, so that it would be before the court. He was shown the document by St. Joe's lawyer. Mr. Beeland was 83 years old, and I guess about 6 months after the case was filed, St. Joe's lawyer took his deposition because of his age and his health in order to preserve it for later at trial. St. Joe's lawyer showed him the document, and what he testified to was specifically he's shown the document, is told it's sort of faint on this copy, but I believe that this is the question. I believe exhibit number 7 is signed in August 5th, 1994. Can you make that out? The answer, well, that's about as close as I could guess is that. Let's assume that's true. I think that is the correct date. It's a question, answer, 8/5/94. I believe that's correct, and I will accept it. Yes, sir. Counsel for St. Joe goes on to ask a series of questions about, well, at the time you signed that, did you know about the condemnation? Did you understand the condemnation was going forward? Mr. Beeland attempts to explain, no, I didn't believe that the condemnation was going forward at that time.
Well, are you trying to assert by this that the 94 document was invalid and that there were no terms, you didn't have a deal with this particular plaintiff?
What I'm trying to assert by this, Your Honor, is that the 1994 document that was used by the plaintiff's at trial and used effectively through the direct examination of Mr. McKeever was used to, number one, bolster Mr. McKeever's testimony that there was, in fact, an oral agreement, and it was used to undermine the credibility of Mr. Beelan, when in fact the document was a fabrication, and that had we had this information, we certainly could have argued in a full and fair trial to the jury that Mr. Beelan, to the extent he purported to recognize that back in 1997 when his deposition was taken at 83 years old, was simply mistaken, and had that argument for the jury to make the determination as to whether or not that existed.
Well, so I'm still trying to understand. Are you saying that the 94 agreement was just completely bogus and that St. Joe had no kind of agreement like that in 94?
Absolutely. That the 94 authorization, and the importance of the 1994 authorization, and we have quoted in detail beginning, I think,
well, that's a pretty significant factual issue, right? I mean, that's a pretty important thing to this case. So why did it take you that long to figure out if the signature on this particular document was right or not?
Because, quite frankly, St. Joe and St. Joe's counsel didn't examine it in a forensic fashion. They'd shown it to Mr. Beelan. He was 83 years old. It was a document that was prepared by Mr. McKeever, who was his friend.
Was there any other officials or officers at St. Joe that would have any knowledge at all, other than Mr. Beelan, of the workings of this particular plaintiff and what the agreement was?
The testimony by Mr. McKeever and the argument, frankly, by plaintiff's counsel is there were two people that knew whether this agreement existed. Two people, Mr. Beelan and Mr. McKeever. They argued at trial and at closing argument and in the briefs.
Nobody else had anything to do with this land deal?
There were other people that had something to do with the land deal later, yes. But in terms as to whether or not this authorization had taken place in August of 1994, after the Cabinet had voted to go forward with condemnation, no. There were two witnesses to this, and they would have been Mr. Beelan and Mr. McKeever.
Well, if you got both of the people saying that the deal was in effect, what are you going to prove by showing this was some kind of photocopy?
Well, first of all, Your Honor says it's some kind of photocopy. It's a fabrication.
But how are you going to prove that?
Pasted the document.
How will you prove that? How will you prove that? Other than saying that this is a photocopy signature, how do we know that Mr. Beelan didn't authorize somebody at St. Joe to put that on there?
What you would be suggesting then is Mr. Beelan authorized somebody from St. Joe to cut off of a document signed 2 years earlier.
That's what I'm doing. I'm guessing, but how are you going to do anything but guess once you do this? If they are the only two people, how are you ever going to prove that it was some kind of fabrication by this particular defendant?
Well, let me ask you this, Your Honor. Let's assume that St. Joe had figured this out before trial. They'd done a forensic examination, and they determined that it was a cut and paste. Could they not have come before the jury at that time and said, jury, look, we know what Mr. Beelan said then. Let us tell you why we don't think that matters and what's going on. Number one, we believe we can demonstrate absolutely and unequivocally that Mr. McKeever fabricated this document. If Mr. McKeever had sat across the table from Mr. Beelan and gotten a signed document, why did he need to cut and paste the document? Remember, one of the proffers below in the affidavit of Mr. Bodziak would be that the document from which this cut signature came would have been only with Mr. McKeever, not with St. Joe. So we demonstrate that Mr. McKeever is the one who did the cut and paste.
Wait, no, that's not correct. I mean, that the 92 document was in Beelan's topsail file and had been faxed. So there was that. There was the original and the fax.
That's correct, Your Honor, and that's exactly the point. When you fax a document, if Your Honor faxes an order out, when you fax the document, your fax machine may put artifacts on the document, little lines. You've certainly gotten faxes where you've seen that. What Mr. Bodziak does in his deposition and what I proffered to Judge Smith was that the 92 document, the little piece of the signature that was used for the cut and paste, came from a document faxed from St. Joe to Mr. McKeever. It would have been in St. Joe's file. It wasn't taken from the original document signed by St. Joe.
But you were, I thought you were saying something different a moment ago.
Sorry, Your Honor.
But can you address Judge Polson's larger question? I mean, is this the key to the case? You're saying this would have been impeaching.
Your Honor, the standard is not, is it the key to the case? The standard is it material? I think the trial court below was incorrect in saying it had to be outcome determinative. The case law is that it needs to be material. Alstern versus Shiver and the Louisville and Nashville Railroad case, this court's decision, dealing not even with fraud, a fraud claim, but a newly discovered evidence claim, says that when the issue is fraud, and there the newly discovered evidence indicated it would be fraud, that the standard isn't is it outcome determinative, but is it material? And I would direct the court's attention to the Klein versus Belko case, which we have cited, where...
And that would include materially impeaching.
Absolutely. In fact, it's exactly in Klein versus Belko, because there they said, Belko argues that what happened there was a records custodian testified that Mr. Belko didn't work.
Aren't you essentially taking the position that this was a forgery?
It's a fabrication. I think it's different from a forgery. When you think of a forgery, and maybe we're just mincing words here, Your Honor, when I think of a forgery, I would try to do my best job to write down Judge Polston's name. But I can create a fabrication by cutting Judge Polston's name off of an earlier order and simply photocopying it onto the bottom of a new order. Make a copy of it, and now I've got an order that's got Judge Polston's signature on the bottom of it. It looks like a Judge Polston signature because it is one. And when Mr. Beelan was provided that document in his deposition, that was a copy of a genuine Joseph Beelan signature.
But if it would seem that if was he shown the 92 document as well?
Absolutely.
Okay, so if you have a 92 document and then a 94 document, it would be reasonable to say, well, what's this other one? We have one deal in 92. And if you really didn't have a deal in 94, wouldn't he have said, oh, well, there was no 94 deal. We only had one deal. There was no subsequent one.
Well, two things I would respond to that. Mr. Beelan signed an authorization in 1989, 1990, 1992, and they say in 1994. So as he's sitting there in his deposition being shown this, what he's saying is that, look, I don't believe I signed an authorization after I knew about the condemnation. That's exactly what he testified in his deposition, and that's exactly how the plaintiff attempted to use it at the trial, where when the plaintiff's counsel said, well, Mr. Beelan, they played his deposition and they put Mr. McKeever on, said, well, when you told him, Mr. Beelan, that the deal was done, at least the cabinet vote had been made, did he then tell you, too bad, Mr. McKeever, because you just lost a commission chance? Bear in mind, the whole issue here is there an oral agreement that was modified to cover condemnation. So what's Mr. McKeever's answer? No, sir. As a matter of fact, after he signed afterwards, he signed another authorized representative statement, the 1994 authorization. Trial transcript goes on for 10 pages using that document to say, wait a minute, how can Mr. Beelan get up here by videotape and tell you that he didn't agree to condemnation when after the cabinet had voted to go forward with condemnation, he supposedly signed this August 5, 1994 document.
And we're not.
Excuse me, we're going over. We'll allow counsel on the other side to have some additional time, but let me ask one. Does this record reflect where the parties asserted the original of this 1994 agreement was supposed to be?
I do not believe that the record reflects anything with respect to that. I believe that what Mr. McKeever testified is that he would have been asked by the state to have gotten this authorization.
Right. We're not talking about a brokerage agreement, something hammered out between the parties. We're talking about a state form that would indicates that the person named has authority to act for the owner.
And that St. Joe is obligated to pay any commission. The form also says...
Right, that's the state office the hook
right.
for any...
So the issue would be not coming back in after the fact and the plaintiff or the appellee arguing, oh, this really isn't an important document. What the court has to focus on, what the court below should have focused on, was how was it used at trial? It wasn't used as...
I think Judge Barfield was just asked a very interesting question. If Iverser comes back and says, I need another one of these forms, and one is created and given to him, shouldn't that be in the state record somewhere?
Mr. Ivester testified he didn't recall having asked for any subsequent form. Now, in fairness, you could read that and say, I just don't recall one way or the other, and there's no...
So your theory is that the whole thing was fabricated exclusively and entirely
for this lawsuit,
for the purpose of impeaching?
For the purpose of impeaching
Beeland.
For the purpose, not just impeaching, no, bolstering Mr. McKeever's testimony that, in fact, there was a deal made after the condemnation, and it was used secondarily or also for impeachment. And what we asked for was the ability to go forward and take additional discovery. Remember, this discovery comes about in the midst of trial.
Well, that's my whole problem is early on in a lengthy trial, at last, 10 years later, the light bulb goes on. Is it your position that, I mean, is there some difference between this document and, for example, perjured testimony? You can wait until the trial is over and then begin to talk about it?
I would make no distinction between the document and perjured testimony, and our position, frankly, is there would be both. If, in fact, it's a fabricated document that never took place, then Mr. McKeever's testimony, by definition, has to be perjurous. But, no, Your Honor, I think that what the Stella case says is that if you discover this at trial, you have to try to raise it at trial with the evidence you had. St. Joe did try to raise it at trial with the evidence you have. And the one thing that seems to be being overlooked is...
All right, but you immediately after trial, you run out and get the examiner's question documents. Why didn't you do that during trial?
St. Joe didn't do that because of the trial court's ruling. They would have been able to use the documents in the trial.
Because why?
Because of the trial court's ruling that says that you could show, but the trial court's ruling is probably an overstatement, the trial court's response to the objection.
It certainly could have been proffered.
Pardon me?
It certainly could have been proffered. There was nothing proffered here, was there?
There are many things additional that could have been done. You could have asked for a continuance. You could have proffered. All of those arguments were made. But I think what the case law says is that when you're dealing with a situation like this with respect to fraud, that the standard in terms of what you have to do at that time are relaxed because of what's going on. It's a putative fraud on the court, and that what ought to happen, and all this analysis is going on now, ought to be happening after there had been discovery, after there had been a full evidentiary hearing, so that all of these issues had been out on a complete record rather than so much relying on lawyers' argument and not evidence.
Thank you, counsel. I think we need to hear from the appellee.
Please the court, I'm Stuart Huff, and on behalf of Bruce McKeever, with me is my co-counsel and longtime dear friend, Mr. Ben Wilkinson.
Now, did you all look also in the state records for the 1994 form?
By that time, Judge, there apparently were no more records, but I do want to make a comment because y'all were interested in that, and I think it's a good point. Excuse me one second. Way back, when the second amended complaint was filed, St. Joe's lawyers answered, and 3 exhibits were attached. Exhibit C was this 94 form at the time. St. Joe's lawyers answered, they must have checked. Those documents attached as exhibits B and C were filed with the Board of Trustees of the Internal Improvement Trust Fund, etc. So they apparently knew that they were filed and found them there. McKeever's counsel didn't go look for any. It had whatever had been turned over in his files. Because this issue is so interesting, Your Honor, if I may, there was nothing said about the non-monetary benefits at all. And I know that it takes me less than 1 minute to cover that. And I know that if we get rolling on the 94 form, I'm never going to get back to it. So if I may just point this out. They devoted only 1 page to that $44 million issue. Both of the things that St. Joe tells you was done wrong to them, that the judge wouldn't give instructions, are entirely false. St. Joe says, excuse me, the jury was not instructed to determine whether or not the non-cash benefits were part of the intended commission. On the contrary, Judge Smith read to the jury You will then determine what his 2% commission would apply to. So if you determine that Mr. McKeever is entitled to a commission, then you must determine whether the parties intended for that commission to apply to non-monetary and monetary benefits. Exactly what St. Joe tells you was not instructed. Its second complaint on that issue is the jury should have been allowed to determine whether or not the non-monetary benefits were compensation for the taking of topsail. St. Joe's theory of the case was those monies, those benefits, were as part of a totally separate settlement of other zoning rights with the Department of Community Affairs. Therefore, the jury should have made a determination. Now, that view by St. Joe was totally belied by the consent final judgment in the case itself, which said that non-monetary benefits were part of the taking, and the jury was asked to determine specifically, did St. Joe receive, I quote, did St. Joe receive any non-monetary benefits as consideration for the transfer of Topsail Hill, close quote? And the answer, yes. So I think it took me a little less than I believe. I hope it did. Mr. Wells told you a minute ago two things that I think need to be corrected.
There's something in the brief, and I don't know if there's any record basis, but suggesting that you all engaged a questioner, an examiner of question documents to look at the 1994 and 1992 forms.
Yes.
When did that happen?
That happened over the weekend. They raised this. Y'all were wondering when did it actually come up? They raised this in the afternoon of the Friday of the first week of trial. And Ben and I mean, this was really out of left field. And we contacted someone over in Jacksonville, never got to meet him, faxed him documents over. And by Sunday afternoon, he was of the initial impression, but he wanted to see more stuff, that this was a photocopy of the other signature. So it took, that's how long it took. If you had worked the weekend, you could have known whatever we knew by Monday morning. And their own man, Bodziak, judge, because you were asking logically, why didn't you all find out? Even you had time left during trial. According to them, they retained Mr. Bodziak on either the 17th or the 19th of November after trial. I find it kind of strange that I couldn't figure out which day it was. But by the 19th, Bodziak was able to give them the opinion that the one signature was a photocopy of the other. Now, what I think is really incorrect, question coming or?
Well, I mean, I don't want to cut you off, so go ahead. But I just alert you that hearing that it's a photocopy, it seems to me an evidentiary hearing would be a good idea. And it seems to me, so I want to hear from you why not?
Oh, I think this very clearly. Judge Smith heard these arguments, gave them every chance from November through March 20th to try and prove up, not that the document was a photocopy. That wouldn't, as he said, so what does that determine? As Judge Paulson said, so what does that determine? Where do you get from there? What is this exercise about? How did it affect the case? Is it what you think is a fraud in a vacuum? If you notice, yours did, St. Joe really has only one goal in this case. And it can't, everything else it says is more or less evasive in the briefs. We want an evidentiary hearing. We want more time. We want to buy some time. We want some leverage in this case. We have no leverage at the moment at all. We can't prove that Bruce McKeever created this. And I'll tell you why I really believe he didn't. And it's very clear and easy to see. If Bruce McKeever created this document to help him out later in litigation, that's what the theory is, he would have added one thing that he needed and never got. He would have said, including in condemnation. He might as well be hung for a sheep as a goat if you're going to cut off all of your connections with St. Joe. If you're going to infuriate St. Joe, you're going to falsify a signature. Your main patron, the biggest landowner, and you're not going to deal with them anymore, then you go ahead and if you're going to photocopy a signature, put it on something that does something for you. Don't just put, as you pointed out, Judge Polson, as Judge Smith said also, look at this thing. After the theatrics are over, St. Joe, it does no more than show what was an undisputed fact. What Beeland during his lifetime admitted. Yeah, Bruce was our agent for a conventional sale. You know what's really ironic, Your Honor, about, then I'm not avoiding your question. I'm just trying to say, where would that all go? And after 10 years of this man waiting for a fee that he's
so why does he photocopy it?
He didn't.
Who did it?
He gained nothing out of it. I don't know. I know this, Judge. You even mentioned, and Judge Smith thought, I'm going to run out of time because it's a little factual argument. Unless y'all tell me, I'll give you an extra minute. But St. Joe pulled a kind of a little double switch on the state. It told the state through McKeever, we want to have this condemnation. And then Mr. Thornton in Jacksonville wrote a posturing letter to the cabinet. We don't want to be condemned, not unless y'all pay 3 times what your last offer was. So they bring in the best eminent domain lawyer anywhere, Toby Brigham. And he testified to the jury in this case, I never want my client to look like a willing seller. We have got to always act like we don't want to be condemned. I never want you to be in front of a jury looking like a willing seller at all. Now, if Bruce McKeever, right after that, we know from Pete Mallison, he was high up in a DP. In effect, he turns around and says to Ivester, what is this about with St. Joe? It's yes, it's no. What are they, posturing with us? And he says to Mallison, to Jerry Ivester, can you get something else or get something in writing from him? So that's one possibility. Jerry Ivester says, well, then I'm going to create another form for McKeever that shows he not only was the rep in 92, but he's still the rep. That's a possibility. I'll tell you another possibility.
Okay, so maybe Ivester did it.
I'll tell you another one's not too much of a stretch. But
maybe Ivester took the 92 form and photocopied that and made a 94 form.
Oh, I'm sorry.
Ivester's and he would do that just to avoid the inconvenience of a phone call.
No, because probably couldn't get a phone call from St. Joe. But here's another possibility. Maybe laying right in front of us, Judge. Here's one that may sound like a stretch until you stop and think how really simple it is. If you were clever enough and experienced enough in business, and you had a use for a form that you might or might not want to disavow in the future, and you had your own office put your own signature on it. Stretch? No, not at all. Think about it. You have a photocopy of your own signature put on the form. You can then always offer it for the affirmative of it. Nobody's going to say, it's a bum document. Your name's photocopied. You're going to say, it's my name. What difference does it make? If you want to disavow the document, let's say on Friday during the trial, then you can say, Eureka! I just now was sitting here with my naked eye and I saw that it's a photocopy.
All right, so maybe it was Balin.
Yes, sir.
Okay, all right. I'm just writing this down, the possibilities here.
That might sound off the head.
Ivester. Balin. Now, you're not saying that there's anything in the record that would rule out McKeever.
Oh, no. Of course not.
Okay, so who else?
Did Mr. Beaven really have to have some evil intent, or could he have just done it for convenience if he were out of...
I'm sorry, Your Honor.
Did he really have to do it out of some kind of evil intent, or could he have done it out of just convenience? He's out of town. People have facsimile signatures.
Could have. Yes, sir. Could have done it for anyone. Not evil. No.
We don't know.
We never
we can
will.
speculate. Aren't really the possibilities endless?
Yes, sir. You know what I don't get to do, Judge? Exactly right. I don't get to say, it's very interesting, Mr. Beeland, when you come back to life. Why did you and Mr. Ortel, who used to be your lead counsel and never appeared in this trial again, didn't even come to watch closing arguments, Mr. Ortel and you got together, you took the document, you rehearsed like every good lawyer does, right? We don't call it rehearse, we prep our client. And you're both all ready for it, aren't you? And he hands you over, and you say, yes, I identify that. This is St. Joe's lawyer. And he says, I'm going to make that Exhibit 7 to the deposition. And later, it'll become the most important document since the Magna Carta, as far as they're concerned. Everybody should have been looking at it. Oh, I never thought it would. It's the whole case. Read the quotes. Y'all have read them. Read the quotes now.
Oh, no, are you suggesting that maybe Mr. Ortel did it? Are you suggesting that Mr. Ortel may have done it?
No.
Okay, so we just McKeever, Ivester, and Balin.
I'm out of the list of
Okay.
that I know of, other than anybody, or for an innocuous reason, Balin's office. What I'm saying to you is, with all respect, a document that becomes the thing that changed the outcome against St. Joe. That's the exact quote. I think it's page 26. Changed the outcome was so unimportant for the prior 10 years that nobody thought about it at all. We just took Bruce McKeever's word for it because it was attached to his complaint. We wouldn't challenge him over a $5 million lawsuit, would we? Would that be rude to question him about that document? We never thought of it. Here's one of the phoniest parts, or one of the hardest parts to understand. Mr. Wells, before Mr. Wells got involved, post-trial after losing, St. Joe's lawyer files this affidavit. I was sitting there listening to McKeever and getting ready to cross-examine him, which is the most intense part of a trial, when you're going to do the cross-examination of the lead party for the other case. And sitting there, I suddenly noticed inconsistencies in his testimony. I'm quoting right. What are they? I'm never going to tell you. They're not my affidavit. And you know what they did as I listened? That caused me to pick up the 92 and the 94 forms side by side on my desk in front of me. And I said, well, looky here. They're identical. 10 years into the case. You know what Judge Smith called it? And he's been around a couple of times around the turn. He said, and have you ever read a case ever like this, where the trial judge said the supposed victim actually laid an ambush for the supposed perpetrator? Because this is that case. I've read every one. I've never seen that before. Now, you said I'd get an extra minute because Mr. Wells did, and I'm not going to push it. They say, gosh, if Judge Smith had just let us compare the two signatures with a jury, that would have been hunky-dory. We didn't need any expert, and we didn't think we did. Well, twice Mr. Wells told y'all this morning, you know why we didn't notice the two were the same? Because we had not given a forensic examination to them. Mr. Bodziak apparently doesn't know that you don't need to know anything. He says, I base my opinion upon the techniques and principles of this learned profession. I use my experience of principles, tests, and methodologies accepted in the field of forensics. And in case I get flushed right this second, one last thing was told to y'all, isn't true at all. You were told a minute ago that the only person who could have made that copy was Bruce McKeever, because he's the only one who would have had it. Well, the expert Boziak doesn't know that. If y'all will look, please, at his letter, he says, this was either photocopied from document B, quote, or another copy of document B. In other words, anybody who had a copy of that could have done it. Not the one single key to the door. Any copy of that key is what he really means. And y'all were also told that in order to get this hearing, the acts only had to be material. The evidence only had to be material to the case. And you were cited to Klein versus Belko. But that's not what the 3rd District said at all. the third district said nothing about. In fact, I'll tell you candidly, that shocked me. I've read every single case there is in this field, every one. For this case, no case has said it needs to be only material. Here's what the third district said in that case. His credibility was severely damaged by the evidence. Not, as you were told, it only has to be material. Judge Smith made determination. He is the arbiter of that in this case, of course. He sat there and watched it. He said, if it had not been introduced, it would not have changed the outcome of the case. This form neither tends to prove nor disprove that St. Joe agreed to a condemnation, nor whether McKeever pursued condemnation at St. Joe's direction. In fact, Your Honors, this document doesn't impeach at all Mr. Beal. And if they had chosen
Well,
to...
he doesn't address the impeachment, does he?
I'm sorry.
In what you just read us, he doesn't say anything about impeachment.
No. And you couldn't. Let me just give you a hypothetical colloquy. It's Beelan and I, and he's alive, and I say, Mr. Beelan, do you contend that you didn't agree to condemnation? You didn't agree to it, is that right? And you didn't agree that McKeever should get a fee. You say, that's right, Mr. Huff. That's exactly right. Well, Mr. Beelan, look at this 94 form. Yes, Mr. Huff, I've read thoroughly. Well, doesn't that impeach you? He'd say, on the contrary, Counselor, it proves just what I just said. It doesn't say a word about condemnation at all. And it was signed after the cabinet vote, Mr. Huff. And it says not one word about a fee or a condemnation or anything else. It proves, Mr. Huff, what I just told you. It's a beneficial document to me. And that's why it's Exhibit 7 in my deposition at my own attorney's choosing. It's a beneficial document if you're smart enough to use it that way and say, here is the only document created after the cabinet vote. And it doesn't say a word in the world about a condemnation. Why? Beelan would say, because I didn't know there was a condemnation going on. I was the only adult in North Florida who didn't know that the state of Florida had condemned, the only one. Front page news. And I'm the chairman of St. Joe, and I'm in charge of Top Sale, and I didn't know that? No, really. They did? They voted to condemn it? What a surprise to me. Why, I didn't hear that until next October. Nobody mentioned it to me. I guess it wasn't talked to over at the executive committee. Nobody said, what do you think about us in the state with Top Sale? No, never came up. I didn't know a word about it. You know what impact that had on a jury. Why they came up with that crazy story, I will never know in the end of my life. Jake Beelan said, I didn't know there was a condemnation going on. I never knew it about Top Sale, even though it's front, as they admit, but of course at a footnote, not in the main part, but you saw it. They said, of course, Mr. Beelan was also impeached by a few other things, such as letters from St. Joe, newspaper headlines. Where's that footnote page? I've got it, but I can't read it. Check that if any one of y'all wants to. Page 10 of their initial brief, footnote. McKeever also impeached Beelan that he didn't know about the condemnation, and then they list a host of documents, which I introduced into evidence. But they could have taken that 94 form and said, it sure doesn't hurt us. It doesn't impeach me at all. Sometimes you get St. Joe saying it's the only document that proves that they agreed to a condemnation. Proves it. Proves it. That document says zero about condemnation, and St. Joe has the, not the audacity, the tactical curiosity to me to say, look at it. It proves that we agreed to condemnation. It does. I'm the plaintiff's lawyer. I guarantee one thing. If I thought this document was important, I would have told a jury in an opening statement. I'm not that good, but I'm smart enough to know that the most important document of the whole case that I'm going to mention to somebody, and I didn't. Nobody did.
Counsel, I'm beginning to think that we're just about as entranced as a jury might be, and we're well over the allotted time. I appreciate your arguments.
Get this, but
I'm going to have to
Thank
keep
you.
you the sign on this one, and we will extend 2 additional minutes for rebuttal to the other side.
More than I could have expected. Thank you very much.
Thank you, Your Honor. One of the things that we had asked to be able to get in discovery was, in fact, the expert report of Mr. Quinn to understand, in fact, when that information was provided, our position being that if, in fact, plaintiffs who presumably didn't, at least plaintiffs' counsel presumably didn't know it was a fabrication either, but if, in fact, they had that during trial and then came on the day before closing and said, no, you can't proceed forward to do as the judge suggested you could do to compare these documents, that in itself is inappropriate. And let's look at what we're going here. We now know by then, it's undisputed that it's a fabrication. It's undisputed by cut and paste. There should have been no need for any expert testimony whatsoever. And what that document could have been used for, and what I'd submit the document will still be used for if we're entitled to the evidentiary hearing and discovery, is to, if nothing else, impeach Mr. McIver.
Is that an abuse of discretion standard?
Which is an abuse of discretion standard, Your Honor?
The trial court's ruling on this matter? What's our standard of review?
The ruling, I would certainly agree with respect to the new trial is an abuse of discretion. I'd say whether or not it's an abuse of discretion with respect to giving the evidentiary hearing and discovery is a different issue, since that's supposed to only be based upon the pleadings and the colorable entitlement. There would be, I don't think, any reason to defer to the discretion. We're both looking at the exact same record, much like moving to dismiss on a complaint, and that what the court had said in Southern Bell versus Weldon is, if the colorable entitlement is laid out, you shall give the discovery and evidentiary hearing. You don't do it based on mesmerizing jury arguments. You do it based on evidence. You don't do it based on standing up and say, well, maybe it was Ivester, maybe it was Kuster, maybe it was Boleyn, maybe it was Ortel. You allow us the opportunity to prove it, and one of the ways that we would prove it would be through the discovery we asked for to show that, in fact, that document didn't come from somewhere else. It came from Mr. McIver's file, so that the person who had the motive to do it, the person who had the opportunity to do it, and the person who turns out to have the document from which it is cut and pasted in his file is the one that would do it. And if nothing else.
You're telling me in the course of this 10-year case you never requested a document request for Mr. McIver's files?
No, Your Honor. His documents were requested, absolutely.
Okay.
But I don't know what's been given with respect to that. And certainly they weren't requested like we did here, which was to give us each and every single copy of the authorization so that we can determine whether or not that's the copy that was used for this cut and paste, because that wasn't the focus. And everybody says, well, why didn't St. Joe notice it was a fabrication at the time? Again, it's a cut and paste that has Mr. Beeland's original signature on it. Mr. Beeland, who's 83 years old, and you can prep him, you can whip him, you can work him all he wants. He's still dying. He's still 83 years old. And, you know, your lawyer's got to take what you get with respect to your witness. We didn't notice it, and they didn't notice it for the 10 years either, because one thing you can be sure of, they wouldn't have been using a fabricated document if they'd have known of it. Both parties have an obligation to do this, and it would be turning procedure on its head to say that, look, you've got to look at every document like this with the assumption that somebody has engaged in fabrication. The rules provide for the use of copies and not the use of originals, not requirement for originals. So if we're going to say that someone can come in here and fabricate a document and use the document, but too bad on you because you couldn't find it, I say that's wrong. I think that this court has previously said in these circumstances you send it back for an evidentiary hearing. By the way, the record has Mr. Iverser's affidavit saying he most assuredly did not cut and paste it. Mr. Kuster's affidavit, the other person in the state, saying he didn't cut and paste it. His, Mr. Beeland's secretary, I didn't cut and paste it. That is all in the record and there. The issue is, what will the evidence show in an evidentiary hearing, not what a bunch of arguments will show put together with a lot of passion. It's not lawyers' argument, as the court said in Klein versus Belko and Dynasty, that the trial judge is supposed to be looking at. He's supposed to allow discovery, collect the evidence, put the evidence before the court, and let the court root out whether, in fact, there was a fraud. And that's exactly what ought to happen here. It needs to be sent back to the court, allow us the discovery and an evidentiary hearing, not a hearing based on lawyers' argument, to root out this fraud. Thank you, Your Honor.
Thank you, counsel. Our final case is